Supreme Court established ground rules for the hearing of the petition and issued rulings and issues raised in affidavits and other applications. Leila Mohammed has more on the interlocutory applications that the court had to dispense with in its first order of business.
Arguments by all parties involved in this presidential petition will be made here at the Milimani Law Courts in Kenya, the temporary home for the Supreme Court, where the 7-judge bench will be listening to all the parties involved before delivering their judgment on September the 5th. The court's first order of business to deal with matters submitted before it in petitions filed in the last few days.
9 petitions were filed, and we received 25 preliminary issues in form of interlocutory applications. We have been able to dispose of all those preliminary issues and delivered rulings online, which I believe you are still reading and internalizing.
The court merged issues from 3 petitions, including Raila Odinga Youth Advocacy for Africa and Khalif Khalifa versus the IEBC, its chair, commissioners, President-elect William Ruto, his deputy Rigathi Gachagua, and the Attorney General.
You allocated 3.
The judges ordered the IEBC to provide copies of its technology systems security policy to the applicants. IEBC was also ordered to submit certified copies of Forms 32A and 34C in the impugned election, plus access to any servers at the National Tallying Center for storing, transmitting and voting information. Ballot boxes for specific areas in Nandi, Kericho, Mombasa and Nyandarua counties will be recounted.
2 petitions were struck out.
The court also struck out a petition by Moses Kuria and Kingangi Muturi, where they had asked the court to declare that Raila Odinga's direct or indirect actions on the 13th and 14th of August 2022 at the Presidential Election Tallying Center were aimed at obstructing or hindering Wafula Chebukati and the IEBC from executing their lawful duties in respect of the presidential election held on 9th August 2022, thus violating the Constitution and the Elections Act. The Law Society of Kenya was admitted as an amicus curiae, but the court will not allow them to make oral submissions. The Kenyan chapter of the ICJ has also been admitted as an amicus curiae, but will solely examine constitutional principles. John Walubengo, Joseph Sevilla and Martin Mirero were also allowed in as amicus curiae, however they too won't make oral submissions. The court denied a motion application in the Raila Odinga Martha Karua petition filed on August 27th. The petitioners had asked the court to throw out affidavits by John Githongo, Benson Wesonga, Martin Papa and certain paragraphs in support of that petition. The court ruled that John Njoroge Kamau's petition has validity and would be allowed, but it dismissed the other interested parties in the petition.
For the IBC, I think it's a matter which is live before the court.
In the Raila Odinga Martha Karua petition, the court has declared that it will admit on record the replying affidavits of Juliana Chirera, Justice Nyang'aya, Francis Wenderi and Irene Masit being members of IEBC. The justices denied an application by Agano Party candidate David Waihiga Mwaure as an interested party in the petition.
I've traversed this country. I am very seriously injured, and I need to be given an opportunity under exceptional circumstances, if any.
If you are aggrieved as a candidate, you have the first opportunity, you have a right under the law to file a petition challenging the validity. You did not do that.
Leila Mohammed, NTV.